If you've scheduled your first estate planning consultation, great decision. Today, I'm going to walk you through exactly how to prepare for this consultation so you walk in confident, organized, and ready to get real value from your time with your lawyer. First, get clear on your wishes, concerns, and goals. Before you gather a single document, pause and ask yourself, what am I actually trying to accomplish? What am I concerned about? For some people, the answer is simple. They want to make sure everything goes to their spouse and/or children. For others, it's more nuanced. Maybe you want to avoid probate, protect minor children, plan for blended family dynamics, minimize taxes, or protect assets from long-term care costs. You don't need perfect answers, but you should have a general sense of your priorities. And you want to work with an attorney who you feel comfortable talking about these very personal matters with. It's important that you're able to be candid and open so that your attorney can give you the best possible advice for your situation. Second, think about who you trust. Estate planning isn't just about what happens to your assets, it's also about who is in charge. Before your meeting, think about the key roles you will need to fill. A personal representative or executor, a trustee if a trust is part of your plan, a guardian for minor children, and the person to serve as your power of attorney or healthcare agent. Ask yourself, who is responsible, who is organized, and who can handle conflict? And just as important, who is not the right choice, even if it might feel awkward to admit. You don't have to have final decisions made, but you should walk in with some strong candidates in mind. Many clients are concerned about hurting someone's feelings or that a child may be upset about not being named to fill a certain role. While it's very important to address that concern, it's even more important to make sure that the right people are in place. Third, make a simple asset list. To recommend the right plan for you, your attorney will need a general idea of your overall assets as a starting point. Create a rough list that includes real estate, bank accounts, investment accounts, retirement accounts like IRAs or 401ks or other employer plans, life insurance, business interests, and valuable personal property that is valuable financially or sentimentally. The goal is to help your attorney understand the scope and structure of your estate. And here's a pro tip. Note how each asset is titled if you know. For example, in your individual name, joint ownership, or in trust. That matters more than most people realize. Fourth, know your family situation. Now, this might sound obvious, but it's really one of the most important pieces. Be ready to clearly explain marital status, children, including stepchildren or estranged relationships, any prior marriages, any beneficiaries with special needs, and any family dynamics that you're concerned could cause conflict. Estate planning is not a one-size-fits-all, and family complexity is often where the real planning happens. The more honest and upfront you are, the better your plan will be. Fifth, gather your key documents, but don't become overly stressed about this. If you have existing documents, bring them. This might include prior wills or trust agreements, powers of attorney, deeds to real estate, beneficiary designations, prenuptial or postnuptial agreements, and account statements. But don't panic if you can't find everything. A good attorney can still move forward without perfect documentation, but having what you can find will save time and will help avoid mistakes. Sixth, think about the what-if scenarios. A good estate plan isn't just about what happens when you pass away. It's also about what happens if you're alive but unable to make decisions. Ask yourself, who would manage my finances if I couldn't? Who would make medical decisions for me? Do I have strong feelings about life support or end-of-life care? Again, you don't need to have answers to all of these questions, but thinking through these questions ahead of time will make your meeting far more productive. Seventh, come ready to ask questions. This is your opportunity to understand the process, not just sign an engagement agreement. Some great questions for you to bring. What documents do I actually need and why? How does probate work in my situation? What happens if I do nothing? How often should I update my plan? And what does your process look like from here? And what expenses can I expect? A good attorney should welcome your questions and not just rush past them. Eighth, don't worry about saying the right thing. One of the biggest misconceptions is that you need to walk into your consultation with everything figured out. You don't. Your job is to bring your goals, your questions, and an honest analysis of your situation. Your attorney's job is to guide you through the rest. In fact, trying to pre-solve everything can sometimes lead to confusion or missed opportunities. A final thought, preparation can save you time and money. Estate planning is one of those areas where a little preparation goes a long way. When you walk into your consultation organized and thoughtful, you'll spend less time backtracking, you'll get clearer advice, and you'll end up with a better, more tailored plan. So don't overthink it, but don't wing it either. A little effort now can make the entire process smoother, faster, and far more effective. And if you're preparing for your first consultation, that's great. You're already ahead of most people. Thank you.